As I was riding down the road today, I thought I would make a video on the Georgia Religious Freedom Restoration Act, the RFRA, which is an act that is being proposed by the Georgia state legislators, certain of them, which mirrors, that's the terminology they use, mirrors the federal RFRA. Now, you might ask, in view of the fact that we have a First Amendment which states very clearly that Congress shall make no law impeding the free exercise of religion, then why do we need a law to restore religious freedom that the government has taken away? Isn't the Constitution the law of the land? The Constitution is higher than any law that we might conceive of and enact on our books, yet we seemingly need to have a law to protect the freedoms guaranteed in the U.S. Constitution. Well, the way that this came about is that the federal courts and the Supreme Court have utilized an unauthoritative doctrine. This is a doctrine. This is not written into the Constitution somewhere, that ascribes certain authority to judicial decisions at the federal court level and at the Supreme Court level. And once a decision, or excuse me, an opinion has been handed down, then that opinion can be used as a precedent to define future opinions on issues that are related to the original opinion. Now, they call this doctrine stare decisis, but if you do a word search in the U.S. Constitution, you're not going to find it. So where do they get the authority to use stare decisis in the first place? Well, it kind of makes sense that if a court has decided an issue and rendered an opinion on something prior to a new case developing on the exact same parameters, then it would be worth it for the court to look back at the reasoning of the first decision and then determine whether it is valid and whether it applies to the circumstances of today. And if so, then they could use that as the reasoning to save them the same work. You don't want to reinvent the wheel if it's already been figured equitably. But the problem is here that the federal courts do a little bit more than that. And the Supreme Court does a little bit more than that. They do more than just simply look at a particular case that's already been decided and apply that opinion to an exact same case that they're now looking at. They have been using these precedents and this doctrine of stare decisis in a way that allows them to pick and choose. In other words, they can predetermine the outcome and then cobble together a set of precedents using stare decisis in order to support that opinion. And that is what they've been doing. Getting back to our case here, decades ago, someone in the federal court system created out of thin air a doctrine that they term compelling government interest or compelling state interest as a reason to overrule what is actually written in the Constitution. And by doing that, they can claim that in any particular situation that the government has a compelling government interest to overrule the Constitution again and again and again, using that doctrine as a precedent. And that is essentially what has happened here. So, any number of years ago, the Supreme Court denied religious freedom to an individual, and they used this compelling government interest rationale as the means by which to deny these First Amendment protections. Well, then the situation comes up again and again, and they can use the same rationale again and again and deny someone the protections of the First Amendment, saying that it's compelling government interest. But if you think about it, the government really has no compelling interests at all. I mean, what interests does a rock have? A rock has no interests. What interests does, say, a home under construction have? A home under construction has no interests. You see, a home under construction is simply a contract being executed. If you think about it, that's exactly what the Constitution is. It is a contract being executed. And it is a contract among the states authorized by we the people of the states. The people have all of the interests here. The state has no interest. The federal government has no interest. Yet they use this as a way to deny the people their own interests. So here it is. We have the Hobby Lobby case that comes up where you have a closed corporation, and the owners of this closed corporation have used their religious beliefs as a reason to not incorporate some of the Obamacare regulations into their health care program. And so, of course, the courts claim that they have a compelling government interest for that to be, for Hobby Lobby to lose. However, in 1993, the U.S. Congress put together a law to help minimize the influence of the federal government over decisions like this. And the law is the federal RFRA, the Federal Religious Freedom Restoration Act. They were trying to restore the religious freedom destroyed by the Supreme Court prior to that by its usurpation of the people's authority by denying First Amendment protections. So we have a law, and that law was used to settle the Hobby Lobby case in the manner that the owners of Hobby Lobby won the case. And what this law seeks to do is it seeks to minimize the opportunity for the government to overthrow the First Amendment protections. So now the states are wanting to use that same rationale to minimize this egregious usurpation of the people's authority in the first place, when the government claims a compelling government interest to deny someone their religious freedom. And that's what this is all about. And so, having understood that to this degree, I've made the point with any number of our state legislators that rather than trying to minimize at a state level the possibility of the state using that same compelling government interest criteria to destroy the First Amendment, why don't we create a law that simply says that the state of Georgia recognizes the First Amendment as it is written, that Congress shall make no law impeding the free exercise of religion, and also that the state of Georgia rejects any Supreme Court opinion to the contrary, and enact that as law. and then see where that goes, because that is the righteous way of dealing with a federal government that is out of control. The states are the parties to the contract of the Constitution. The states own all authority over the federal government. The states could destroy the federal government by simply changing the Constitution. They could create a different government. They could say that there is no government. The states have all authority in that. And the states, both jointly and severally, have the authority to deny the federal government the opportunity to destroy the Constitution, because it is this Constitution that constituted the government in the first place, the federal government. So I urge our state representatives and senators to realize that the state of Georgia is supreme over our federal government, that it is a party to the contract that the federal government was created under. And so therefore, to assert that authority against any usurpation, whether it's the First Amendment or whether it's any of the protections, and to enforce the Constitution on this out of control federal government. And if the state of Georgia will take that tack, and if all of the states will take that tack, we can put this country back together pretty quickly.